Hello out there and welcome to episode 69 of the Nursing Home Abuse Podcast. My name is Rob Schenk.
And I'm Will Smith.
And we are trial lawyers focusing in the areas of nursing home abuse and neglect in the state of Georgia. And we are your co-hosts for this particular episode. As this episode goes to air, it is May 21st. We are headlong into spring now.
Mm-hmm.
It's feeling good outside for the most part. Normally would be the time where I would say, it's National Donut Day or it's National Talk Like a Pirate Day or whatever the holiday is coming up or whatever birthdays.
Mm-hmm.
In my research, I haven't turned up anything.
I don't know anything either. I don't know about any of those days in the first place, so there's no reason for you to pause and wait for me to say, well, actually, it's National Mayfly Day, or it's National Beanpole Day.
I queued you up for no reason at all.
No reason at all.
Yeah.
I don't know when National Donut Day is.
Yeah. There's a really good website that we use to turn up those, particularly, like, they're not holidays, but they're like special days. And there's all kinds of days. Like, we could make up our own day.
Yeah.
Like the Will and Rob Appreciation Day or something like that.
We could.
We should do that, but just in our office. Like, hey guys, is there a Boss's Day?
There is a Boss's Day. I know
mean, every
that,
day, obviously, yes. Every day is Boss's Day.
Well, no, there's a day for everything. There is, like, there's an employee day, there's a boss day, there's an attorney day.
Yeah, an attorney appreciation
day.
Yeah,
there's a judge day. There's, there's a day where I think there's one for moms.
I don't know.
There's a dad day. Anyway.
I haven't heard of those.
Okay.
So
if that's what you have to say about those kinds of days.
Yeah. No,
it doesn't matter anyway.
You can. That's epic. Faith No More. Is that what you're doing right now?
No, I was just rhyming everything with day.
Okay.
All right.
I thought you were singing a song. Anyway, a lot of interesting topics for this episode of the podcast. Talking to you about stories from around the country regarding nursing home care. We're going to direct your attention, dear audience, to Fresno, California. Fresno is in what part of California, Will?
I have no idea.
Why would you be mad about that? I'm just asking you.
Why do you cue me up for these random things? It's not like you're asking me something like...
It's a pop quiz.
Yeah, don't.
If I had to guess, I would say that Fresno is
south.
I was going to say Northern California.
Fresno?
Is Fresno where they grow wine? Well, you don't grow wine. You grow grapes for wine.
Yeah.
Fresno. I wish we had Alexa here. Like, Alexa.
Well, we do have these devices.
Alexa, where is Fresno, California?
We do have devices that have literally all...
And I will say this. If I were to play this episode at my apartment, and because I said Alexa, it's going to actually do the function.
Yeah.
Is it Northern California? Hit the map button.
Because I don't know what it's going to do when I press the map button.
Actually, Gene, can we get a graphic of the state of California on the screen so that we can, we can see where...
See, this is the problem, is that when I hit the map button, it wants to give me directions.
That's fine. No, just pull out.
Oh, it's Southern California. It's below San Francisco. Look at that. It's above...
Man, that is of the same latitude as San Jose, which is Northern California. Los Angeles, that's like 500 miles from Los Angeles. It's Northern California, so that's fine. Anyway. All right. We ready?
Yeah, go ahead.
All right, here we go. Are you going to try to confirm that it's not Northern California? Is that what you're trying to do right now? Okay. All right. A former resident of Bella Vista Memory Care Community in Northwest Fresno contends in a civil lawsuit that he had to have his right eye removed after staff at the nursing home allowed him to be attacked twice by his roommate. Josh Dansby Jr. is seeking unspecified damages in Fresno County Superior Court for elder abuse, negligent hiring and supervision, and assault and battery. The attorney for the Sierra Meadows Senior Living LLC, which runs the nursing home, sorry about that, that's the corporate company that operates the nursing home, said the allegations are false and, quote, provides nothing short of stellar care and is a local leader in the industry. And further went on to say, this is simply another shakedown type of lawsuit that has plagued many other local businesses in the valley. He criticized the looks like the
he posted a lot of on social media about the lawsuit.
Yeah. So he's criticizing the attorney for posting about this lawsuit.
Mm-hmm.
So at any rate, Dansby suffers from Alzheimer's and dementia and has a history of strokes and heart attacks. He also has had cornea transplants in both eyes and a pacemaker. Around February of 2017, he became a resident of the nursing home. Garcia says in the lawsuit that Bella Vista focused on its bottom line at the expense of the care it promised to provide Dansby. In doing so, Bella Vista placed Dansby with a roommate who had a known history of aggressive propensities and physical assault. In September, the roommate attacked Dansby. After this assault, Dansby's family complained to the Bella Vista staff, asking that Dansby be protected from the roommate, but Bella Vista staff falsely told the family that there was no alternative way to protect Dansby. Dansby remained with his roommate and was attacked again in December. After the attack, Bella Vista staff did not provide Dansby with care for days. He was later taken to St. Agnes Medical Center's emergency room, where he was determined to have suffered a corneal detachment. The doctors then had to remove his right eye. So the first thing that I think should be addressed is this is not a case in which a staff member has physically assaulted a resident. This is a resident roommate attacking another resident. So what is the liability in instances where you have resident on resident violence? I know we've touched on this topic several times in this podcast, but I think it bears repeating that in a case, and I would say, we don't know all the facts, but just based on these facts, I feel if they're not refuted, the nursing home will be liable, because the nursing home is liable for the reasonable, foreseeable acts of violence committed by other residents.
And it's not the first time that he's done it, so they know that he has a proclivity to do it.
So in this case, I think that, something that would be important to know is, are there any vacancies? Could they not have moved this person?
Mm-hmm.
Could they not have put him in the violent person? Could not put him in his own room? Or could not have moved Mr. Dansby out of this room? 2 attacks is too many. 1 attack is that's what you get. That's your constructive knowledge in terms of this nursing.
Sure, yeah.
So after the second time, get him out of there.
Yeah.
Otherwise, in my opinion, you're liable for whatever attacks come after that.
I'll agree with that. I'll tell you one thing I don't like about this issue, this article, this issue, and I kind of side with the nursing home about it, is I don't like the use of extrajudicial statements. This is not the same as the case that we had in Georgia with the...
I'm sorry to interrupt you. What is an extrajudicial statement?
So it's when you make statements outside of the litigation process. So let's say that you're in litigation, you're in a suit. You're either the plaintiff or defendant, or you're the prosecution or you're the defense, and you're making statements outside of court to the media, usually to the media, but like to people who are not involved in the litigation process. So you're posting on social media, that's improper. You're posting, you're talking to news media, that's improper. This is not the same as the case we had in Georgia where, and we talked about this, it must have been 30 or 40 podcasts ago, where there was a nursing home in Toccoa, and this firm outside of the state of Georgia was targeting that nursing home in advertisements by talking about the deficiencies that CMS had found. That is a different matter. In this matter, I don't know what he was posting, but this attorney was making those extrajudicial, outside of the court, statements about this case. And I don't like things like that. They have to be done very carefully. They have to follow certain bar rules. And, in cases where there might be a class action, you have to get signed off by a court. Like, you see those commercials where it goes, you or a loved one have mesothelioma, or, in a case like asbestos is already, there's been a fund set aside for people, but in all those mass torts, there's a certified class, so they're allowed in limited circumstances to make those statements. In this one, I kind of agree with the nursing home. I don't really like the attorney doing this. At the same time, they need to be sued because they knew or should have known that this is a reasonable outcome. But yeah, I don't like it when attorneys make those kinds of, because why are you doing that?
I'll tell you what extrajudicial comments that I do like is when I'm not in this case, because in this case it's the lawyer that said this was a shakedown, but oftentimes you'll get the nursing home administrator or somebody representing the corporate entity that owns and operates the nursing home saying things like that, where this is just a shakedown. This is an ambulance chaser that's going after this, because that's going to go right up into closing argument. It's going to get blown up. His picture's going to get put up underneath it, or he's going to be asked about it in his deposition. But using the term shakedown type of lawsuit, and we talked about this, but like what is a shakedown? I feel like our civil justice system, it makes it impossible for there to be a shakedown lawsuit, because at least in the state of Georgia, if you want to file a medical malpractice lawsuit, you have to hire an expert to sign an affidavit to get on your side to get in the lawsuit, and then you got to go through the motion to dismiss process. I mean, like if a real shakedown would be the family members of this nursing home going into the house of the person that owns the nursing home and literally shaking him down.
Like Suge
Knight style to Vanilla Ice.
Yeah.
Which, by the way, Will had I think it was probably a 6 foot by 6 foot poster of Vanilla Ice to the extreme poster in his bedroom throughout his whole life, actually.
No, I did not.
Yeah.
That is not true.
But at any rate, those are the type of extrajudicial comments.
And what they're, to expound upon what Rob is talking about, the concept of a lawsuit shakedown is that, look, we have filed a lawsuit against you, and we know that we're not going to win it because we don't have a claim, but it's going to cost you X amount of dollars. Let's say that it's going to cost you, $60,000 in legal fees to defend this, and it's going to drag your name through, the news cycle, and it's going to make you look bad. So if you want us to go ahead and settle it, then you give us, let's say, $30,000. So you get out of this. We sign a release confidentiality agreement. It's all said and done. The thing is that probably does happen. I'm not going to deny that happens. I don't see it because it doesn't really happen in our industry. Because like Rob said, these cases are very expensive for the plaintiffs to file. And if you don't file it properly, it's going to get dismissed immediately. You got to have an affidavit. You're not going to file a lawsuit against a nursing home in Georgia and then go to the defense firms that we're familiar with and say, listen, we know we don't have a suit, but if you guys will tell your client to pay us some money, we'll go away. I know for a fact that they won't do that because we constantly tell them we have a suit. Your client needs to settle, and they refuse. They will fight tooth and nail. So this whole shakedown trope is just something that the industry pushes out there to poison the well.
Even so, like, you put all the malicious lawsuits, all the shakedown lawsuits you want into it's a drop in the bucket compared to all the claims that do not get prosecuted because no one finds out about it. Like how much money the industry saves because people don't have video cameras in their loved ones' rooms, or we can't prove exactly that this infection was caused by the bed sore. This type of thing. They're acting like this is some type of this is going to kill the industry. No, your industry survives because there's not enough people doing this. Yeah,
I agree with you. And, I think that the public has this weird relationship with lawsuits anyway. The same people who I know have used the phrase frivolous lawsuit will often come into an attorney's office for the most minor thing and say, well, what do you mean I can't sue them for emotional damage? My DirecTV doesn't work now. But it's misinformation that's pushed out by the medical provider, industry. You constantly hear one of the reasons that we need tort reform is all these frivolous lawsuits. Well, what is a frivolous lawsuit? How many are out there? I have had discussions with very, very well-informed, intelligent people that I thought, who were doctors or nurses, and they have said, well, yeah, I agree. My medical malpractice insurance is going up because of all these frivolous lawsuits, and I can't get a simple answer from them about the question, how do you know that? What frivolous lawsuits are you talking about? Name one of them for me. All you know is that the health, your medical malpractice provider said, hey, listen, we're going to have to get more money from you because all these frivolous lawsuits, and you're believing them. But it's like Rob said, at the end of the day, a frivolous lawsuit is not something you can pursue because it's going to get kicked out of court.
Yeah, there's a lot of stop fails for the type of thing that gets thrown out.
And there's a huge market for urban legends on lawsuits to begin with that have really misinformed the public on tort law and what you can do for everything from, well, did you hear about the burglar who fell through a roof and then ended up suing the people who own the home because the roof wasn't intact? Like that's not how that works at all.
To circle back to the original point that I want to talk about with this article is the issue of resident violence, and the main principle that I want to say is that if there's no propensity for a resident to be violent, then if the resident just one day gets triggered and assaults another resident, it's not very likely that the nursing home should be held responsible because they have no actual knowledge that that's going to happen, and they don't have constructive knowledge, which is a fact or evidence that would lead them to believe that that's going to happen. So no constructive knowledge. That's a big difference between a resident that has a history of violence, particularly against an individual resident.
Yeah.
So in this instance, you have 3 assaults between the same 2 dudes. So, not only is the history there, but I mean, like, it's almost like an exact, it's like, Breaking 2, Electric Boogaloo. It's the same people doing the same dances. So, I think that there's a strong case to be made that Will wanted to laugh with the Breaking reference, but there's a strong case to be made that they'll be successful in this count if the facts hold up and are not rebutted with that. So, where are we going next? This is an interesting article.
Okay. Yeah.
Where are we going? Are we going patient dumping, or are we going the flu shot?
Let's go with the flu shot.
Okay, so this case is we got this from the Washington Post. Nursing home forced employee to get flu shot despite her religious objection, Justice Department suit says. Barnell Williams didn't want a flu shot, but the nursing home where she worked forced her to get one after she explained that the vaccine went against her religious beliefs. Her body, Williams allegedly told her employer, is a holy temple, and the Bible prohibits her from putting foreign substances into it. On Tuesday, this is from March of 2018, this is a few months old. On Tuesday, the federal government sued Wisconsin's Ozaukee County, claiming that Williams faced religious discrimination in 2016 when the county owned the nursing home, Lasada Care Center, mandated she get a flu shot to continue working there. So she was fired. She cried uncontrollably when she got the lawsuit, etc. So what? I didn't. Have you ever heard of somebody in terms of not a science objection to flu shots, but I've never heard of a.
I believe that. And I might be mistaken, but I'm pretty sure this is Jehovah's Witness, the same people that have had the Supreme Court cases about blood transfusions. But from my understanding, they also don't have a clergy letter requirement. So, you can have these small offset groups that have pretty radical beliefs, because I don't think that a belief in mainstream Christianity is that you can't have flu shots, that don't require like any sort of clergy verification. And I think that this county, if I recall, didn't have a clergy verification requirement.
I see.
But that being said, I am, just like the Supreme Court cases, the Jehovah's Witnesses that don't want to get blood transfusions or don't want their children to get them. But this is an issue where...
This is tough because, I mean, like, you have this person's religious beliefs versus what's healthy for the nursing home that she works at.
It's not tough for me in that I certainly don't... I think the tough part comes from whether or not we ever get to a point where we make it mandatory that you must get a flu vaccine or certain kinds of vaccinations to protect the public at large. For me, as far as this case is concerned, the simple solution would be, no, you don't have to get a flu shot. Good luck on your future employment. You can't work here. I mean, I know she's claiming Title VII, which is the, employers can't discriminate based on religion, but,
Well, that's what this is that she was fired.
Sure. But, it's a danger to everybody there. I mean,
We should have somebody on the show about, like, because I don't know is it not mandatory that nursing staff in hospitals get flu shots?
I was never mandated to get one. I don't think that Clay is.
I'm ignorant to that.
Yeah, we could just very easily. I'd ask my brother, because
get Clay back on.
Got to get Clay back on here.
Yeah, have Clay as a co-host.
But I don't know.
This is interesting. This is like liberal value versus liberal value on this. This is interesting. It's an interesting case. I just thought I'd bring that up. It was interesting. Where are we going to next? Let's see.
What about the Jewish man that was murdered?
Okay, let's see. So yeah, out of Yonkers, New York.
Yeah.
41-year-old Alan Califano walked into new Jewish nursing home in the Bronx, New York, attempting to rob an elderly resident and then beat the 84-year-old victim while yelling anti-Semitic remarks at him. Califano was charged with robbery, burglary, a hate crime, assault, and possession of a weapon and marijuana. The police report claims that Califano walked in the facility, asked to use the bathroom, and the new security guard on duty let him in. So he didn't murder him, he just beat him. Looks like, let's see, so the security guard let the man into the home to use the bathroom. Instead of going to the bathroom, the intruder started rummaging through the apartments, eventually ending up in the victim's apartment where he lit a joint. He hit the resident in the mouth, in the face, and the director of the assisted living facility said that the victim was a wonderful, kind, and gentle man, and that, quote, this isolated incident is the result of an unacceptable breach of protocol committed by a guard employed by the private firm contracted to provide security at this assisted living facility.
So this is certainly an interesting liability issue because, it's not as though you have the type of situation where you can't predict what your employees are going to do. It's more like the situation we talked about a few podcasts ago where the woman was pushing a laundry cart and she hit a resident in a walker. There should be protocols in place. There are 100% going to be protocols in place that deal with entry and exit points of an assisted living facility. So the issue is going to be who's liable, this independent contractor or the nursing home. There's no question in my mind, it'd have to be proved, through litigation, but there's no question in my mind that this guard committed negligence. You cannot have an entry control point that has completely permissible entry. Why do you have a control point? And what I mean by that is that all entry control points for security reasons are semi permissible. Like, so that certain people have permission to enter them, certain people don't. Otherwise, just have an open door there that anybody can go in and out. Save yourself the trouble of having a guard there, right? So clearly this guard is there to ensure that not just anybody from the streets walks in. When a random person, and this, I feel like there might be more to this, that a random person walked up and said, "Hey, can I go to the bathroom?"
They go to the bathroom. Maybe it's different in New York City. I don't know.
I do not feel like it would be. I mean, maybe, I don't know, maybe, but it seems like he should be accustomed to turning people away all the time.
Yeah.
It sounds really weird that he just let him in there, but to what extent is the nursing home responsible for the actions of, if it is an independent contractor?
And why we'll keep saying independent contractors, that generally in the law from state to state, an employer of employees, W-2 employees, is generally responsible for the negligent acts committed by the employee. Generally in the law, a business is not responsible for the negligent actions of an independent contractor. That's just varies from state to state, and it varies on the facts. There's concepts like a sensible agency, these rabbit hole legal things that there's exceptions to the rule, but for the most part, that's how it works. So that's why the woman spokesperson for the assisted living center underlined and bolded that it was a private firm that's not an employee of the nursing home. That's the reason why.
So imagine this. Imagine like a nursing home hires an outside company that does lawn care, right? And that Joe Mower is the guy that they send over there to cut the lawn. And let's say that the company that he works for knows that he's reckless, knows that he's violent, and knows that he has a history of attacking people, and they send him over to the nursing home. The nursing home has hired this company. They come over there frequently to cut the grass, and while he's there, Joe Mower attacks one of the residents. Well, certainly Joe Mower's company that he works for knew about this, knew that he had a proclivity towards this, so you can make an argument easily that, you guys knew he did this kind of thing, so you might be responsible. But is the nursing home responsible? I mean, what do they got to do to make sure that these independent contractors that they hire are doing their jobs? I mean, they have to be reasonable, but I would imagine in this case that they're not going to be held, in this case in New York, that they're not going to be held responsible here, because it just seems, I wouldn't be surprised that they found out that this guard
they knew each other.
They knew each other.
Yeah,
because that just seems so strange to me.
Strange. What is not strange is that we've reached the epic ending, the conclusion of this particular episode of the Nursing Home Abuse Podcast. And I'm gonna put a scenario to you, Will. I do this often. You're walking down the street, all right, and a random person walks up to you, exasperated. They're pulling their hair out. They're clearly.
He stops me and he goes, "Sir,
in
sir,
distress.
sir."
Yeah, sir, please. He puts his hand on your arm like it makes you very uncomfortable, and he looks at you and says, "I have to know right now where I can get the Nursing Home Abuse Podcast." What do you say in response?
I'd say, number one, nursinghomeabusepodcast.com.
Okay. He says that doesn't work for me. I don't want that.
Okay, then I would say try Spotify, where you can listen, you can stream our nursing home podcast.
Okay.
If he says that doesn't work for me, I would say iTunes.
He says
I can't do that. Then I'd say anywhere that you listen to podcasts or download MP3s or audio, you're going to find the Nursing Home Abuse Podcast.
I would say that's absolutely right. Spotify, iTunes, Stitcher, Potty Pod Potters,
and these are
Podmasters.
The last of these are ones that you've made up. But I think most people are going to go to nursinghomeabusepodcast.com. They're going to go to Spotify, or they're going to go to iTunes.
That's right.
We are not yet on Pandora, nor will we ever be.
Or on Pod Puppies.
Yeah. I don't think there is a Pod Puppy.
Okay, so We appreciate your attention, and I guess with that, we will see you next time.
See you next time.
Thanks for tuning in to the Nursing Home Abuse Podcast. Please be sure to subscribe to this podcast on iTunes or Stitcher, and feel free to leave us some feedback. And for more information about the topics discussed in this episode, check out the show website, nursinghomeabusepodcast.com. That's nursinghomeabusepodcast.com. See you next time.